This is Michael Popok, Legal AF. I told you before that every time Donald Trump wants to file something that has no merit or low merit in a courtroom, he's going to use Alina Habba, and it's happened again. In the E Jean Carroll case, no less, a case where he's already lost the first round, a jury in New York finding that he sexually abused a crime in the state of New York, E Jean Carroll in a dressing room in the spring of 1996. The only reason the jury couldn't find or didn't find rape, which is also a crime in the state of New York, is because they couldn't figure out whether he inserted his finger or his penis into E Jean Carroll because her eyes were closed and she couldn't testify as to that. Leave aside the anatomical differences between those two things and what the jury probably concluded. In any event, sexual abuse is just as bad as a rape. But not to Donald Trump. He believes he's been vindicated. Yay, a jury in New York has only found me to be a sexual abuser, not a rapist. And he doesn't like the fact that E Jean Carroll goes on her social media and on her interviews and says that she was, of course, vindicated by a jury of 9 people in New York and says, see, I was sexually abused. He is a rapist. Well, he doesn't like that. He doesn't like being called what the jury ultimately almost concluded is that he raped her. So he's now countersued as of a late night filing, countersued E Jean Carroll. I mean, I have to shake my head, arguing that he was vindicated because he was only found to be a sexual abuser. And every time she says rape, he gets defamed and he suffers substantial damages. All right, now let's unpack this. Like I said, Alina Habba files things without merit, and she generally, almost universally, loses. She loses so badly that another federal judge in Florida, Judge Middlebrooks, sanctioned her over $1 million along with Donald Trump for filing a meritless case against Hillary Clinton, the Democratic National Committee, and all sorts of other Democratic leaders just a year ago. But that wasn't enough. She apparently is a glutton for punishment, Alina Habba, and she's going to do it again. So without obtaining leave of court, I'll talk about the procedure in a minute, she filed her answer, which is the second part of the pleading. When you have a complaint against you, the other answering paper is called an answer. It often comes along with affirmative defenses or defenses that you need to plead. If it's an affirmative defense, it means you have the burden of proof. And so there's affirmative defenses that you actually have to put down on paper in your answer. There's other defenses that you don't have the burden for, like more of the way of an avoidance. You're avoiding the allegations, and therefore they don't necessarily have to be pled, but most people put that in there. And if you've got a counterclaim, at least one where it already hasn't been rejected by the judge in the past, hint, hint, then you can add a counterclaim or a cross-claim against another party that's not currently in the case. You can cross-claim people. You can counterclaim people. Those are parties that are in the case that you can kind of across the V, right? Plaintiff v. defendant. You can counterclaim and you can cross-claim. Well, they filed a counterclaim against E Jean Carroll, basically saying, yay, we've been vindicated. We're only sexual abusers, not sexual rapists. And therefore, Donald Trump has been defamed. Let's stop right there. In order to plead a count for defamation in any state, you have to have a good reputation to begin with. It is the case that there are certain people who could never be defamed because their reputation is already in tatters or in the dustbin of history. Hitler can't be defamed. Right? We could reel off a number of people who can't be defamed because of their own DNA natural reputation is so poor that it can't be defamed. I would posit that Donald Trump falls into that category of somebody based on his own actions, his own activity, the multiple criminal investigations, indictments, judgments against him, and civil and criminal matters, that he does not have a reputation that can be sullied. That is what I posit on this hot take. And there is case law to support that. There are certain people, rare categories of people, who are basically so bad that nobody can defame them. Jeffrey Dahmer can't be defamed. See where I'm going with this? Okay, now, that's one. Two, in order, even if he was somebody that could be defamed, right? He has a good reputation that has now been sullied by E Jean Carroll saying rape instead of sexual abuse. There has to be a damage resulting from that. And he was found by a jury of 9 people. He was adjudged to have committed sexual abuse because they found that he put at least his finger into E Jean Carroll's vagina. Okay? That's what the jury found. So now you're going to have to argue to a new jury and to a judge and to a court of appeals that you've been damaged because there is a difference, a qualitative difference in people's minds between a sexual abuser and a sexual rapist. Let me let that land for a second. So to the average reasonable person, Donald Trump has to argue that there is a damage difference between being called a sexual abuser and being called a rapist. And it's that delta which would be his damage. I don't think to the average person there is a difference. That is a distinction without a difference. We're now talking about how many devils can dance on the head of a pin, to paraphrase. So, I don't think he can be damaged. He's a person whose reputation can be damaged. And I don't think they're going to ever find, and I think this doesn't even get to a jury, probably with motion practice before the trial judge and ultimately the Second Circuit Court of Appeals, that there is no real damage that he suffered. Now, there is a type of defamation, what's called defamation per se, which the law allows you to bring a defamation case even if you can't prove damage, if it sullies your professional reputation, accuses you of a loathsome disease or a crime. So you could go into court and argue for defamation per se, even with this nickel or less of damage. You don't get attorney's fees. If you just want to have the Pyrrhic victory of having, a jury say that you're right, you could do that. The other type of defamation is defamation per quad, which requires special damages or damages to be established. It's unclear from the way he's brought his claim. I think he's under both per se and per quad. In any event, again, it starts with a premise from an elemental standpoint of the claim that he can be damaged. His reputation can be injured by anybody else. And based on his own conduct and reputation in the media and otherwise, I don't think he's able to get over that basic threshold. And then we have the damage issue that I've just outlined. Now, Judge Lewis Kaplan, the federal judge, is going to have to decide either procedurally on a motion to dismiss, which we know is coming. Robbie Kaplan, no relation to the judge, the lawyer for E Jean Carroll, is going to file what's called a letter brief with the Southern District, New York federal judge Kaplan, in which, because this is the procedure, she's going to ask for leave to file a motion to dismiss. And in her motion to dismiss, which will come in the next 30 days, she's going to argue that Alina Habba needed permission from the court in order to bring this counterclaim, because this is not the first time that Donald Trump has tried to counterclaim against E Jean Carroll. He tried it before, I believe, with Joe Tacopina in charge, and it was denied as being untimely. Joe Tacopina got in late in the case. Alina Habba's been in the case forever. She screwed up a number of deadlines and missed deadlines in federal court. Big no-no when you practice in federal court, right? It gets your claims barred or dismissed, or it can. And Joe Tacopina tried to bring a counterclaim, and the judge says too late. So I think they needed leave from the court to bring this counterclaim and not just add it on, tack it on to their answer. And that, I'm sure, will be something that Robbie Kaplan will address in her moving papers, which will soon be there. In the meantime, on the first case in which Donald Trump lost $5 million, he's already filed a motion with the judge for a new trial. That's going to be denied. To reduce the jury award from $5 million to $1 million, that's going to be denied. He's also appealed the first jury verdict finding him to be a sexual abuser and having to pay her $5 million. He's appealed that to the Second Circuit. He had to post a bond. We talked about it on Legal AF, the podcast only on the MeidasTouch network that I co-anchor. We talked about that. He put up a cash bond of $5.5 million. probably because he can't get a bond from a bonding company. But so, and that stays the enforcement of the judgment. In other words, he doesn't have to pay the $5 million while the appeal is going on, as long as he posted the $5.5 million into the court registry, meaning deposit it with the court clerk. They have their own bank account. So that's what's going on in that case. In the new case that's been filed, he's tried to counterclaim. I think it's procedurally defective. I think from a motion to dismiss for failure to state a claim, it's defective, because I think they're going to argue now that Donald Trump can't ever, in our lifetime, be defamed. And he can't prove any damage between the delta of being called a rapist and a sex abuser, because to the free-thinking world, it's basically the same thing. I mean, frankly, New York is a minority state when it comes to crimes about sex crimes, because in most states, whether it is your finger, a weapon, or another part of your anatomical being that you insert inside of a woman, that against her will, that is rape. That's rape. In New York, they get very technical. If it's the penis, it's rape. If it's not the penis and it's everything else, it's other types of sexual crimes, sex crimes. And in this case, sexual abuse. And we were there in court on civil sexual abuse, not criminal, because the statute of limitations on the crime had already expired in New York, but not on the civil case. And that's how we got to the civil case. I follow developments in the law at the intersection of law and politics, politically charged litigation matters about every day. Sometimes it feels like about every hour, only on the MeidasTouch network. We then pull it all together. We curate a long form podcast called Legal AF on Wednesdays and Saturdays, only on the MeidasTouch network. You see where I'm going with this? You're watching me on YouTube on the MeidasTouch channel. Subscribe. It helps bring the content to you that you enjoy. It helps me bring this level of content to you if you give me a thumbs up and leave a comment. And I've been known to open up a dialogue with you in the chat. You can also follow me, Michael Popok, on all things social media at MS Popok. This is Michael Popok, Legal AF reporting.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.